Welcome back from this short break and moderating our third panel on what the current antitrust and merger rules deliver and what they don't is Pierre Gibault, Chief Economist of the Director General for Competition here at the European Commission. And panel 3, we have with us today Margarida Matos Rosa, President of the Portuguese Competition Authority. She is an economist by training with a master's in public administration. Margarida brings her years of experience in the private sector in economic research, investment banking, and investment management. We also have with us Martin Peter Schinkel. He is a professor of economics and professor of law by affiliation at the University of Amsterdam. His research interests include industrial organizations, competition policy and regulation, public and private enforcement. He is particularly interested in the interplay between law and economics. He has also published on the topic we will be discussing today. Then we have here with us Vanessa Turner. She is a senior advisor for competition at the European consumer organization BEUC. Prior to this, Vanessa was a partner in private practice, a member of cabinet of the European Commissioner for Competition Policy, and special advisor to the US FTC. She also held senior positions at Visa Europe. We also have with us Dirk Middelschulte. He is Global General Counsel for Competition at Unilever. After starting his career in private practice, he held a number of roles at Deutsche Bahn and its headquarters in Berlin in 2006, and then was Global Compliance Director at Danone. Pierre, over to you.
Thank you very much, and still good morning by just a few minutes. As you know, the competition authority, DG COM in Europe, wield mostly three different kinds of tools: antitrust, merger regulation, and state aid. It is therefore important in the perspective of the Green Deal that we make sure that the way in which we use and wield those tools is compatible with the goals that the Green Deal is trying to achieve. In particular, are we using those tools in a manner which is too lenient, too strict, just right, or maybe are we kind of clear enough? For example, are we clear enough about the conditions under which companies might be able to cooperate in order to help the European Union and its economy reach some of the targets of the Green Deal? In order to address this issue, you already know that we have a very distinguished panel representing very kind of different constituencies and point of view, from policy to consumers to business to academia. And we will break up essentially this panel in kind of three modules. We'll start with a brief discussion of innovation. It's not the same thing as the previous panel, because here what we will have is a bit more of a kind of a policy, down-to-earth perspective. Then we'll move to the issue of coordination. Under which condition can coordination between rivals or potential rivals be admitted? And are the conditions spelled out conducive to the realization of the Green Deal? And then we'll finish with a more specific issue, which is an issue of green efficiencies, and whether the provisions that we have for the taking into account of efficiencies are sufficient, and in particular, whether the provision that usually limits us to within market efficiencies is something that would need to be revised. Okay? So let's see what this brilliant kind of cocktail of speakers will deliver on those themes. And without further ado, let's start with the issue of innovation, where Margarita is going to be the main speaker. To kind of frame the issue, why innovation? Let me go back to something that Executive Vice President Timmermans said this morning, is that if you look at the emission of the EA in terms of CO2, it's less than 10% of the world's CA. So you might tell yourself, why bother? And there are several reasons to bother. The first one is pointed out this morning, is that the EU is an example. In terms of competition policy as well, we have many agencies around the world that look up to us and often kind of follow our lead. So that already kind of increases the influence of whatever we might do at a competition level to favor kind of the Green Deal. The second one is that in the last several years, under Executive Vice President Vestager's lead, we have introduced more and more innovation as a crucial aspect of our analysis, both in antitrust and in merger review. It would therefore be a little bizarre that when we start thinking about the implication of those tools for the Green Deal, where innovation is very, very important, we would not take care of this. Why? Because, as I've just said, we might be small in terms of the emission, but if we favor green innovation, we can also help not only the EA reduce its footprint, but the rest of the world to reduce its footprint. And we can do this also in a way that essentially will give a leg up to EU business in this new green economy, which to me seems to be an attractive proposition. And then finally, while maybe the meat of this discussion is going to be about coordination between partners and the efficiencies that might be taken into account, there are actually some quite similar issues between what the effect of, say, mergers and antitrust on innovation might be, and those that will be raised within the coordination issue. And especially the kind of synergies, the kind of efficiencies that might arise will, as you will see, prove to be crucial. So, Margherita, the floor is yours. Thank you.
Thank you, Pierre, and good morning to all. It's really a great pleasure to take part in this conference. And when I was preparing for the panel, I realized I had almost forgotten that back in 95 and 96, I had worked for a brief period of time on tradable permits, including at DG3 at the time, which was DG Industry. And at the time, this was really groundbreaking work from an institution, and it was putting academic work into practice. Now, 25 years later, I see European citizens continue to put the environment at the top of their values, and that the European Commission continues to be an ambitious institution at the world scale. So congratulations on that. It has been said earlier in the conference that competition law is not the primary instrument to achieve green objectives, but not being the lead actor in the green script does not mean that competition does not have a role to play. So the discussion must then seek to strike the balance between ensuring efficiency and fair deals for consumers in the future while seeking to become a climate neutral economy. And this balance is being devised taking into account the three aspects you mentioned that are being discussed throughout the conference today: state aid, which in my view is the preferred vector for a strong contribution to the Green Deal objectives, horizontal agreements, which we'll tackle later, and merger review. So our goal here today is, of course, to promote an open and constructive debate. And going straight to merger review and innovation, I would start by saying that we should demystify views that place competition policy as an obstacle or as adversarial to sustainability. In many respects, this is quite the opposite in my view. Competition and innovation are generally positively correlated. They tend to go hand in hand, and this is true for competition and green innovation as well. It has been said throughout the morning as well that competition is one of the key drivers of the incentives for firms to innovate. It is contestability that induces innovation. And historically, innovation has led to significant productivity and welfare increases, but also to sustainability increases. And why? Because firms want to develop more efficient production processes. This gives them competitive advantage over rivals. More efficient production processes often means that an important part of process innovation is green innovation. Think of the cases where firms focus on spending less energy or reducing and reusing waste or on using renewable or more durable inputs. So the first point I'd like to make is that strong competition creates incentives to reduce costs through innovation. A second point I'd like to make is that strong consumer demand for green products is also a strong incentive for firms to be more sustainable in their production processes and in the products and services they offer. In fact, I believe consumer demand is extremely powerful in driving change, and consumers are valuing sustainability now more than ever, either because they see sustainability as a good in itself or because they value sustainability features embedded in products. And we can think of examples that include fuel efficiency in cars or energy efficiency in household appliances or the convenience of online services. What is true is that consumers' willingness to pay for green is an extremely powerful incentive for green innovation by firms. So keeping competition conditions strong is therefore a strong contribution of competition policy for the Green Deal. So how do enforcers do this in practice? Let's briefly look at the role of innovation in competition assessments. As an example, innovation and R&D took center stage in the Commission's assessment back in 2017 in the Dow-DuPont merger. And also in notable cases afterwards, Bayer Monsanto, for example. The Commission at the time had found significant product and pipeline overlaps, as well as innovation capability overlaps. And so in order to preserve incentives for innovation, which is key here, the clearance of these mergers required significant divestiture commitments by the merging parties involving their R&D capabilities. In the Bayer-Monsanto merger, for example, the analysis of the Commission considered whether the merger would hamper innovation competition for crop protection and seed industries. And this included the development of more environment-friendly products. So it was considered that consumers could be harmed in the short run by the loss of product quality and variety, and in the long run by a significant loss of innovation, given the incentives of the merging parties to delay or redirect or discontinue innovation efforts after the merger. So the debate has prompted recent literature that highlight the role of competition in promoting innovation. And these have been important breakthroughs for competition enforcement that we should count as a very important contribution for sustainability in green innovation. Maybe another message drawn by competition authorities is that they need to be vigilant of attempts by incumbents to protect their market power through the acquisition of disruptive entrants. So if incumbents who are lagging in terms of green innovation adopt a killer strategy so as to prevent or delay the introduction of green innovation to the market, they may, under certain circumstances, through the merger review process, be halted by competition enforcers. So to finalize, this, in my view, is one of the best contributions of competition policy to the Green Deal, because merger review can keep innovation alive. And I'll stop here, Pierre.
Well, thank you very much, Margarita. Also, thank you for keeping a good time. That gives me maybe the opportunity to take one of the questions from the audience. And there's a question from Cecilia Borelli, who asked, do you think that antitrust has a role to play to address obviously environmentally harmful cooperation? So in other sense, we always think about, there's corporations that can be very positive. Are we blocking this? But there's the other side of the coin, is that some cooperation might actually be quite harmful.
There may be cases in which cooperation is harmful indeed, although this may be probably the topic of the next subject we will address as a panel. Of course, there are cases in which cooperation may be allowed, and we'll see that in a minute, and other cases where yellow or red light is seen by enforcers, and there are conditions to look at that are provided for in Article 1013. But I don't want to jump into the next discussion, so I'll just restate what I said regarding innovation. It's competition is really, as it has been said in the morning, namely by, I think it was Philippe Aghion, competition is really at the heart of innovation. So we must keep that process extremely strong, especially, I would add, in the current circumstances that we are in. We need to maintain competition rules and the competition assessment strong, especially for preparing for the economic recovery that we must address as of now. Thank you.
Much. And as you say, the topic of innovation is so intimately linked to the next two topics of our discussion that we should probably better just move directly to that. And we're therefore moving to the issue of cooperation between potential rival or actual rival. And on this point, we are very proud to have Professor Martin Peter Schinken, who is going to tell us what economics has to say about that. Martin Peter, the floor is yours. Thank you.
Thank you very much, Pierre. Thanks also to the commissioners for the Commission for organizing this very important conference. So let me begin by saying that I very much applaud the objectives of the Green Deal. I think it is fantastic that we are having this ambition to be a climate neutral continent by 2050. I would say the sooner, the better. And also, I want to admit that I am a big fan of my countryman, Frans Timmermans. I think he's great, not only in this domain, but in others as well. But this panel is very concretely about the question whether we should revise the competition rules with an eye to promoting sustainability and promoting the green agenda, obviously. Now, and I'm afraid that if we're going to relax the competition rules, and that's exactly what's on the table, and the Dutch Competition Authority, and the Commissioner Vestager has already alluded to that this morning, the Dutch Competition Authority has gone ahead in this direction and has stretched the requirements for exemption under our version of Article 1013, and it's calling the Commission to do the same in the revision of the horizontal guidelines. Now, if we're going to go in that direction, I want to warn that there is actually a great risk that we will end up going against the objectives of the green agenda. I fear that the current enthusiasm behind the green antitrust movement, although very sympathetic, is getting the economics wrong. And it's mainly driven by lawyers so far, so it's important that economists also start getting into the debate. And I think Philippe Aghion made a great contribution and has a fantastic paper also on this very subject that is core to the point. Now, so I've done quite a little bit of reading up on the literature and a little bit of research myself as well. And the bottom line conclusion is that, I come down on that competition rules are fine as they are, if not, should be enforced a little bit stricter in this domain. If anything, competition authorities should be careful to have a keen eye for collusion, even under the guise of green now in this context, and also mergers, for example, green killer acquisitions, because concentration tends to reduce the incentives of companies to take sustainability efforts. So rather than relaxing the competition rules, which is on the table now, I would urge the Commission to think about supporting member states in implementing regulation, because vertical regulation, that is the economic 101 public economics teaches. That is the way to go when there are externalities, which are the root problem, of course, of pollution and climate change, rather than allowing for horizontal agreements. Now, why is this? The reason is that ultimately competition is a driver of green efforts. And what we are talking about here, also what is behind the Dutch Competition Authority's initiatives, is not so much R&D incentives, although as just said and also previously this morning said that their competition is also an important driver, but we are talking more about the implementation, the transition to cleaner ways of producing, or fairer ways of producing for that matter, without child labor or with fairer wages to farmers in third world countries and so on. Now, green is a dimension of competition amongst companies. There's a lot of research on corporate social responsibility. A small part of that research on companies taking corporate social responsibility is actually taking the question of what's the role of competition in it seriously. And that literature overwhelmingly shows that companies do more corporate social responsibility, take more corporate social responsibility when they are competing, and less when they're not. And ultimately, the idea is that consumers have a willingness to pay for products that are produced, and that has also been said several times. There's an appetite for products that are produced in greener ways. And firms can typically differentiate themselves on the green dimension, build a green image, show that their products are produced with less pollutants in them, and so on. And then, because it's costly, obviously, to implement cleaner ways of producing, filters, or shift to another lower emission technology, then if you allow companies to coordinate these investments, these efforts in switching, then they are actually likely to, they have all the incentives at least, to reduce those investments. And together with Josie Spiegel, we looked into this a couple of years ago in a very basic IO model, established stuff. If there's even the smallest willingness to pay on the part of consumers that the firms can cash, can monetize through that form of product differentiation, then the point is that the incentive to invest is always bigger in competition than in coordination. So it's sympathetic to think that they should coordinate, but then they will set a lower standard rather than the standard that we would end up with, the investments that we would end up with in competition. So Member of Parliament Giggle, for example, said this morning, we should not call companies that want to jointly set a standard a cartel. But we have to be careful because that minimum standard that he mentioned, that might be, if it's coordinated, that might be a lower standard, easily might be a lower standard than the standard that would appear in competition. Now, this applies to mergers as well, very much the same. It also applies when companies have intrinsic motivation to do green, because then also they will compete and in competition do more on green. Now, one final remark, this leads me to, I think we should be careful revising competition laws, also because when you think about the practicalities of it, so the implementation, the Dutch Competition Authority really wants to look at these cases and has in coal and chicken, the chicken of tomorrow, and energy agreement. We have to keep in mind that this puts the Competition Authority in a position where it will constantly, if it wants to give exemptions and gives exemptions, it constantly will have to monitor these agreements for doing enough green for the price increase that the companies will do on the back of it, because the incentives are just not right. And so that means the Competition Authority needs an enormous amount of information to monitor this constantly. It will overburden the competition authorities. And in fact, I fear a risk of cartel greenwashing, because by which I mean that in cooperation, companies are going to do too little green for the price increase. So that's a first risk, this cartel greenwashing and this overburdening of the competition authority. And a final and second risk that I want to point out is, and this is also has been very much seen in the Netherlands, by pointing at this form of cooperative self-regulation, the proper regulatory authorities, so the government that has to directly regulate these problems, such as in the chicken of tomorrow in the Netherlands, could just directly regulate that chicken should get better living conditions. The government gets an excuse pointing at the competition authority, pointing at self-regulation for not taking its responsibility. And that, I think, is another risk. So those risks together lead me to conclude that's a sympathetic movement, the green antitrust movement. But I think we should be very careful stretching the laws in this direction or otherwise risk doing damage to both competition and the environment. Thank you.
Okay, thank you very much. Margarita, it's you again. From the point of view of the policymaker and one with an economics background, how do you see the kind of regulations for agreement? Are we getting it right? Are there specific things that we should change for the Green Deal? Are there specific risks?
So the first point I'd like to make is that enforcers acknowledge that firms wish to operate in a predictable and certain environment from a legal standpoint. And in fact, enforcers strive to provide as much clarity as possible. The second point is that the current debate on competition and sustainability has revived and acknowledged the flexibility provided by European law. The law indeed allows for some agreements to take place, and it occurs to me that we may need to effectively communicate the leeway that already exists in our competition framework regarding sustainability initiatives. And this means communicating not just to firms, but also to other stakeholders, including consumers and society at large, so that the debate is not skewed against competition law. So openness and guidance to stakeholders may be key to avoid businesses shying away from sustainability initiatives, but also to avoid giving the wrong impression to consumers that competition law is not open to agreements between firms. It is open under certain circumstances. Accepted agreements may include, as you know, standardized packaging, waste production and waste management, standardized certification and labeling. And when some of the conditions in these agreements are not in line with the principles set in the regulations and in the guidelines, then these are cases that likely deserve further scrutiny from enforcers. Let us not forget, and I think this is important to note, that the primary responsibility as competition enforcers is to ensure that sustainability agreements are not used to hurt competition dynamics nor consumers. So applying Article 101 is a mission that needs to be carried out, and we only have enforcers to do that. And moreover, in my opinion, Article 101 is not currently in a situation where we are over-enforcing it. There's maybe some under-enforcement still going on, and we need to strive to enforce it well. And the risk, you mentioned, Pierre, the risk of cartels being hidden behind sustainability claims is real. It exists. It happened before. But there are also other risks for like having firms disclosing a significant volume of strategic information to each other. And maybe having commitments for sustainability being used as focal points for coordination. So we also know empirically that cartels are more likely to be formed when economic conditions vary in a way such that markets become more predictable. So a final point for me, and because, as I said before, we need to take all circumstances into consideration, our economic recovery will need competition rules to remain strong, not to be relaxed, nor mild, nor lenient in the coming times. The internal market, in my view, needs to remain open and to remain innovative, and particularly under current circumstances. Thank you, Pierre.
Well, thank you, Margarita. Now, Dirk, for a perspective from the other side, the side of the business who is facing this demand for kind of green innovation and greener production, but is also facing a set of regulation. How do you see it?
Thank you, Pierre. So look, Unilever and many other businesses want to make an important contribution to the Green Deal and actually have even more ambitious goals in many instances. So for Europe, for instance, strives to be climate neutral by 2050. And Unilever and many other companies have pledged to achieve this target even significantly earlier. And there are many other bold commitments, voluntary commitments out there. I believe these ambitions are driven by genuine purpose, recognizing that capitalism in its current form creates many great things, but also many terrible outcomes. And so the question is, how can companies indeed drive change? The good news is that, as was said previously, competition provides a very fertile ground. More sustainable products help to distinguish brands and bring about competitive advantages. And there's ample evidence of superior performance of sustainable brands and of sustainable companies. So if the case for unilateral action is strong, where do we need cooperation between the competitors? Let me give you an example. Unilever produces deodorants under brands like Dove and Rexona, and we developed a technology that allowed to compress them. Deodorant bottles were thus much smaller, which means less packaging, less emissions from production and transportation. We made the intellectual property available to our competitors, but they decided not to adopt it. Consumers saw the smaller bottles on the shelf, didn't have time to think about it, and though it was explained that that was not the case, believed they get less value for money. The innovation failed, and the compressed deodorants were delisted. State aid is a great tool to pursue green policy objectives, as the Commission has impressively shown regarding the COVID response rescue packages. But state aid wouldn't have helped compressed deodorants to succeed. And similarly, regulation is absolutely pivotal to drive sustainability, but I have never seen regulation requiring consumer goods companies to compress deodorants. There are many other examples where regulation is lacking, not feasible, or too slow, and where individual action has not delivered the desired results, often because of first mover disadvantages, like in the deodorants example. Also, sometimes cooperation may be necessary to actually achieve regulatory targets. If countries across the EU introduce plastic taxes, which is good as it creates a sustainable level playing field between companies, an existing problem becomes even bigger. There are just not enough recycled plastics available on the market. Maybe there have to be joint efforts of companies in the form of joint bidding or joint and binding offtake commitments on a big scale to convince recyclers to create the necessary infrastructures and to invest in new technology and new plants. So cooperation can fill a gap that unilateral action and regulation cannot close. To be very clear, and I fully agree with Martin Peter and Margarita, This may not lead to fake initiatives where companies are greenwashing anti-competitive conduct. Sustainability collaborations have to be rigorously assessed on their merits, and there's no place for any collective action that doesn't deliver real benefits. These initiatives fall often outside Article 101. And as a matter of fact, industry collaboration is a reality in many spaces. And this is where we see we are outside 101 in the safe spaces. This ranges from loose joint emission reduction commitments to voluntary standards or R&D corporations. And to the extent that these initiatives are not appreciable or have no appreciable effects, the Commission probably doesn't have to reinvent the wheel, but indeed, as Margarita indicated, I think it would be good to have more clarifications to address a often perceived lack of legal certainty and already therefore has a chilling effect. The problem is that many of these light touch industry initiatives that are not appreciable under competition law haven't delivered the environmental or social results that the parties have been hoping for. I think we have to look at how industry cooperation can make a real difference without violating competition law and without greenwashing. The EU courts have repeatedly said that other treaty objectives like environmental protection have to be considered in competition enforcement. And even the Commission recognized this in the CSET case, where companies agreed to phase out washing machines with a bad environmental footprint. I'll pause here and come back to the question how we integrate sustainability and competition policy in the next block.
And now for the fourth angle, from the policy, from the economists, from the business community, to an angle which is of course very important to us, since we are supposed in the end to protect consumers/citizens. From the point of view of Consumer Protection Association, what's your view, Vanessa?
Thank you, Pierre, and thank you for the opportunity to speak today from the perspective of European consumers on this very important topic. The Green Deal and sustainability more generally is a key priority for European consumers, as already been said. And at BEUC, we spend a lot of time considering how to support this and how to make it a reality. So coming to the specifics, we've heard different views on whether current competition law is a problem for cooperation agreements on sustainability. I would tend to the view that it generally does not get in the way and that effective competition is indeed beneficial or rather essential for the green economy as it is for other sectors. On the other hand, recognizing firstly that cooperation can be useful in some circumstances to achieve Green Deal goals, and secondly, that there are many voices calling for an overhaul of competition law on cooperation agreements, I would like to make 2 points. First, I would agree with Dirk that lots of cooperation agreements will fall outside of Article 101 because they don't actually restrict competition. Not every restriction of conduct will amount to a restriction of competition. Or cooperation agreements can benefit from block exemption or individual exemption under 101(3). So we must not lose sight of this when we're focusing on the specific problem areas. However, having said that, there does at least seem to be a perceived problem for Green Deal cooperation agreements. Submissions from lawyers and industry in response to the call for contribution have fairly universally suggested that the law is not clear enough. So this does suggest a lack of clarity, not necessarily a problem of strictness. And I would say it is true that Commission case law and formal guidance has taken various twists and turns over the decades. And perhaps in addition to that, sustainability has brought some types of cooperation into sharper focus. So looking at this, the main themes that have come out of the consultation where further guidance has been called for include information sharing, R&D, joint purchasing, infrastructure sharing, and standardization, labeling, or consumer information. And this is an important area, as Dirk's deodorant example illustrated. We can argue about whether reliable sustainability information is just best achieved by industry agreements or by regulation, but a clear and trustworthy sustainability information, in the absence of this information, this leads to a demand-side failure. So creating it will influence consumers' willingness to pay and thus encourage companies to innovate and compete for consumers' businesses, as Margarita said. Businesses said that they are worried about the serious antitrust liability consequences of getting corporation decisions wrong, and that's holding them back. And I have some sympathy with that. Therefore, to deal with this perceived competition law problem, I would fully agree with Executive Vice President Vestager and Margarida that further guidance and clarity must be provided so that there is no excuse for industry not to get on with cooperation that would be beneficial to everyone, including consumers. So then turning to my second point, do we actually need to expand the scope of non-problematic corporations to accommodate potentially valuable corporations? Is there a problem of strictness of the law here? Here, I would agree with others that say that no major change to competition law is required. We need to be very wary not to undermine a system that has served consumers and indeed society well. On the other hand, climate change is an existential challenge, so we can't be too ivory tower about our thinking. So perhaps we should not rule out all flexibility, but in opening the door, we must stay firmly within EU competition principles and objectives, including consumer welfare. There are red lines that should not be crossed. One such red line is not trying to squeeze the whole Green Deal under the Albany-Wouters line of case law. The exclusion of a broad swathe of green agreements between competitors from Article 101.1 is not comparable, in my mind, with the exclusion of collective labour negotiations or niche self-regulation rules for the legal profession. To take this approach would risk undermining the well-balanced system of Article 101.1 and 101.3 as a whole. Such a degree of public policy shift can only legitimately be done through regulation. Regulation may lead to increased prices for consumers, but this would be decided not by business in its self-interest, but by democratically elected institutions who can weigh up the different interests at stake. This is a different proposition to competition authorities deciding that other public policy should override consumers' interests, which competition policy is ultimately there to protect. It would be an untenable burden on DG Competition or NCAs, and one they shouldn't take on. I'd like to just close here with a quote from the submission from Brozzoni and Capozzi at the Luis School of European Political Economy. They say, "It is worth recalling that whereas for environmental protection, EU law provides several alternative instruments. For the protection of less wealthy consumers from restrictions of competition, the application of competition rules is the only available tool."
Thank you very much. Now we have at this point a few minutes maybe to look at a few questions or respond to each other. So let me try to guide you through this a bit. Alec Bernstein says, panelists have neglected the concern that uncertainty deters benign cooperation. Vanessa is on point, but I think that there's an agreement there. Essentially all of you have said that there need to be further clarification of the restrictions so that business do not feel unnecessarily deterred. But from that point of view, there was another question from Clement Ziegler, which just said, look, suppose we go the route of comfort letter. And that question was directed to Dirk. Suppose we go the route of comfort letter. If you get a comfort letter for your kind of agreement, would there be kind of a rationale for making those comfort letters public so that other people in the industry or similar industries kind of learn from other people's experience?
I think I can give you a short answer. Definitely. I think to the extent that no business secrets, etc., are at stake, that we may have to redact, etc., as always in these cases. I believe these comfort letters should be made public in order for other industries to benefit from these insights and also build on the sort of guidance that the Commission is creating over the course of time with hopefully a growing number of decisions, comfort letters, and guidance notes in this space.
Okay, thank you. Then I have maybe a question about what you guys said. And clearly, the economists have said, look, there are guidelines that tell you that you can cooperate if the synergies, efficiencies are big enough, da-da-da. But then Dirk came back with examples that, the audience might not feel certain about whether they fit within those guidelines or not. I can think of two examples. He mentioned something which is often mentioned. Sometimes there is first mover disadvantage in promoting a sustainability or a green norm. The second example he mentioned about the plastic is that if there might be kind of necessarily specific investment further downstream or upstream in the vertical chain, and in order to kind of incentivize this investment, you need enough commitment by the potential buyers. So there's a bit of a free rider problem between the potential buyers in offering those commitments. Okay, so given that, maybe Martin, what do you think of this kind of example? Do you think that they're satisfactorily addressed by our guidelines? How would you react to that?
Yeah, thanks, Pierre, for that opportunity, because I exactly raised my hand in the chat to ask this question to Dirk. So the example of the compressed deodorants is a nice one, and it relates, of course, to this idea that somehow consumers have no willingness to pay, and that can be the case. If I correctly understand it, consumers didn't understand there were some benefits to the environment from compressed deodorant, which it doesn't sound as a terribly ambitious product to me, but okay, that might be the case. So there are issues where consumers need to be explained probably better. And there might be some downsides to the product. For example, in this case, it being smaller, looking like it contains less. But then, of course, and the Dutch Competition Authority, for that matter, talks extensively about this idea of first mover disadvantage. Now, first of all, of course, the standard economic term is first mover advantage, not first mover disadvantage. But okay, let's say that this might be the case. Sometimes it might be difficult for companies to product differentiate and explain to consumers. But then, of course, if we're going to take this route of an exemption on the 1013, we really need to ask the question, if there is no willingness to pay amongst consumers, and surely there's some cost for the firms to implement this new product, then why would we expect firms in cooperation to take care of this? They would still not have an incentive in cooperation to take care of that. So why would that be the case, is my question to Dirk. And the second problem is that Article 1013 seems a very unfortunate route to try to then arrange this, because it requires that consumers are compensated. Now, get a fair share of the benefits. Now, fair enough, maybe we can stretch this. Maybe that's too strict a compensation criterion, and we're going to talk about that in a minute. But in any event, if there's no willingness to pay at all with consumers, their fair share is going to be zero. And I think that would be, in any stretch, too little.
Okay, so thank you for this reaction. I don't think we have the time to get into a full-fledged debate on that. So we're going to slowly move to the third part of this panel, which is the efficiencies. And of course, we've already kind of touched upon this. And actually, if I look at my series of questions coming up on the screen from the audience, most of them actually fit within this discussion of efficiencies. And let me start with a message which I think was also from Clement Ziegler, but it has disappeared, and who asked a question about the first condition of Article 1013, and saying, shouldn't essentially the conditions there go beyond just economic efficiencies of production and be a little bit kind of more holistic? And keeping this, as I think, as a pretty good introduction to our debate, our discussion about efficiencies, I go first to Vanessa.
Thank you, Pierre. Naturally, out-of-market efficiencies is a very important topic for consumers, and I'll look at it from the lawyer's perspective of the criteria of 1013, and in particular, the first and second criteria of that article. So, but before I go there, I would actually argue that a precondition for even considering a broader interpretation of, in particular, the second criterion of 1013 in relation to cooperation agreements, the precondition is maintaining the existing strict interpretation of the third and fourth criteria. So indispensability and no elimination of competition. But no elimination of competition does not need to be across all the parameters of competition, but it should include price to protect the most vulnerable consumers. Failure to maintain strict indispensability would facilitate greenwashing, which we, I think, all agree is a serious issue and needs to be tackled, or could lead to cartel-like spillover effects. So I think these two criteria are tending to be overlooked in the current debate, but they are extremely important from the consumer perspective. So then turning to the implicit question raised in the Slido, as regards the first criterion of 1013, I would not see a problem in principle or in law to interpret sustainability improvements as quality improvements or new improved products. But then that raises the question, what are the implications and difficulties of looking at out-of-market efficiencies, or put another way, expanding the concept of allowing consumers a fair share? So my first point would be that the treaty says consumers, not citizens. Some would like it to say citizens in terms of out-of-market efficiencies, but we can't ignore the fact that the treaty doesn't say that. Does that mean we can't take out-of-market efficiencies into account? I don't think that the answer to that is no. I think that while maintaining the traditional interpretation of benefits to consumers in the market directly affected by the corporation, that is certainly a sound basic principle. But the existing case law makes clear that exceptions are possible. For example, for future consumer benefits, these can potentially be taken into account in the same way as we look at innovation cases. Out-of-market efficiencies have also been identified by the court in two-sided markets, such as in the MasterCard case, and in cases such as Compagnie Générale Maritime. Having said all that, there must, however, be a limit beyond which the concept of consumer under 101 is rendered meaningless, and that is a red line that EU competition law cannot legitimately cross. In both the judgments I just cited, the court said that regard should be had to the advantage arising from the agreement in question, not only for the relevant markets, but also for other markets. And to me, that implies that consumers directly affected by an anti-competitive agreement must have some more than marginal benefit. You can't solely look at out-of-market benefits or at consumers as an abstract class, as some have argued. Cooperation agreements which reduce climate change and potentially other environmental harms will, however, inherently benefit consumers of the product concerned, in terms, for example, of their health or ultimately, I guess, life. The same does not, however, apply to other policy areas necessarily. So if you can establish clear rules for when out-of-market efficiencies can be taken into account, the concept of consumers getting a fair share is then the second potential difficulty that Martin Peter already alluded to. And he also alluded to the approach of the Dutch Competition Authority, which I think is an interesting one. As long as consumers of the product affected get a benefit, as I said before, to my mind, fair share does not require 100% compensation, where the cooperation agreement internalizes a clear negative externality, or where the consumer's consumption decision imposes costs on third parties. While incomplete compensation of the consumers in the markets affected is arguably not in line with the Commission's 2004 guidelines, although there is some ambiguity, it can be supported in the case law. It would also seem pointless to consider out-of-market efficiencies at all if in-market efficiencies also have to compensate consumers fully. But if 100% compensation is not required in market, how do you determine a fair share is then a really important third difficulty. And do you need to quantify this equation in every case? I'll leave that difficult issue of how precisely one would do this to the economists, well, at least for today, as I've just about used up my 5 minutes. But I would say that if we're going to go down that route of doing calculations in that way, we would likely need to involve new branches of economics, environmental economics, shadow pricing, behavioral economics for looking at willingness to pay and behavioral biases. So I think Pierre's going to need a bigger team. But to conclude, from the consumer perspective, for a cooperation agreement to be saved by out-of-market efficiencies, we must be sure that we have clear, legitimate ring-fencing principles and appropriate quantification tools to remain within the consumer welfare-based system of Article 1013. If we can't do that, as essential as realising the Green Deal is, competition law cannot and should not be distorted beyond its foundations and objectives. Then we do have to use regulation. Thank you.
Thank you very much. Dirk, let me turn to you. I can guess that, like many people in business, some of your reaction to when economists say, look, you know, there's a willingness to pay, it can be a source of advantage, so what are you complaining about? I'm characterizing here, of course. You can say, well, there's not always a willingness to pay, or if there's a willingness to pay, it might come from people who actually do not use the product. So I would suspect that you at least have a priori some feelings that one should have some sympathy for taking into account out-of-market efficiencies. Is this correct? And if that's correct, how do you think we should proceed?
I will try to give you an answer to this question and address the points that Martin Peter and others have made previously. I agree with very much of what Vanessa has said. I disagree on one point that she made in the first block, but which is relevant here, which is the interpretation of the Albany and Lotus case law on public policy objectives and how they can be considered in Article 101. She did not quote a very similar decision, the Mecca Medina case, where the court said, and I quote, for competitive sport to be conducted fairly, ensure healthy rivalry, safeguard equal chances and the integrity and ethical values in sport. These are criteria that can exclude a cooperation from 101. And I think can very well apply this reasoning to agreements that, for instance, foresee a common commitment to human rights in the supply chain. I think that's not a stretch. And also, it's, of course, not a carte blanche for companies to do whatever they want under a sustainability cover. But let's look at 101.3 and how sustainability benefits can be considered. It is clear that price reductions are not the only benefits that are relevant in 101.3, but also quality and innovation. The law speaks about benefits that promote technical and economic progress. I don't think that you have to stretch the language to find that many environmental and social improvements meet this criteria. For instance, the environmental benefits of the joint offtake agreement for recycled plastics in my earlier example. But there are many types of scenarios you could think of. If you're interested in a comprehensive overview, Google Unilever competition law. It's the first hit, and you will find a comprehensive paper on that topic. To take one important category, impactful industry cooperation may require to agree on mandatory, not only voluntary standards, and I mean rigid standards, not those that help you soften the rules. Let's assume, in a simplified example, that the automotive companies agree to transition to only use carbon neutral steel for cars sold in Europe, and only for premium cars, to address a concern that I know Vanessa has around less affluent consumers. It is also clear in the example that the car makers may not even think about discussing price or pass-through of the additional costs. That remains an autonomous decision, and the safeguards need to be put in place and enforced. It would still be a restrictive practice if the price increases are significant, which they are likely to be, because a car contains almost a ton of steel. So one positive consequence of the agreement would be that steelmakers would have to accelerate the development of carbon-free steel and the necessary technology at scale. Prices would decrease over time as carbon-neutral steel becomes more mainstream. That is a straightforward benefit, consumer benefit. But I think the Commission would also have to take the massive reduction of carbon emissions into account in that collaboration scenario, which is indeed the more holistic view that somebody referred to earlier. In other words, the avoidance of negative externalities or true costs, as Vanessa said, with the true costs of steel with a heavy carbon footprint. And many speakers before, like Sven Giegold, the lady from the European Trade Union Association and Juliette Delarue from Klein Earth made this particular point. I believe the Commission should give us guidance for such cases. There are refined tools in state aid and public procurement law to deal with and also to quantify negative externalities that the Commission could build on. I don't think, and this is probably where I agree with the other speakers, I don't think that consumers' willingness to pay for the reduction of these costs is a good measure. First, when consumers are ready to pay more for a sustainable product, competitors don't need to collaborate because the cooperation is not indispensable anymore in the sense of 1013. And then also, which consumer are you talking about? There were two interesting surveys from Eurostat last year. One of them found that 66% of consumers are willing to pay more for sustainable food products, but only 19% of consumers actually buy more sustainable food products. There are many explanations for such behavioral biases, and as Vanessa said, I think, Pierre, you and your team probably have to extend your activities into behavioral economics, which I suppose you already do to a certain extent. And we all have these biases more or less consciously when doing our shopping, but I don't think that they should determine how competition policy is embedded in the Green Deal agenda. It is better to look at the polluter pay principle, I believe, which is well established in European law. The buyer of a more sustainable premium car, in my example, avoids external costs that would otherwise have to be borne by everybody, and notably those that can't afford luxury cars. Improving the car buyer's environmental footprint is clearly a consumer benefit also for the car buyer. The car buyer profits when she or he buys a product that avoids the carbon emissions of a ton of steel that he or she is exposed to together with everybody else. This is just one example, but the result that I at least would be very comfortable with as a competition lawyer, as an employee of a company that I think should be able to explore similar solutions with industry peers, and also as a potential car buyer. It would be good to hear what the Commission thinks of such cases. Thank you.
Okay. Thank you very much. So you've seen two partly compatible, partly different kind of views on the kind of benefits that should be allowed to. Going back to the Master of Economic Orthodoxy, Martin, how do you react to that?
Well, Pierre, directly to your question, out-of-market efficiencies, of course there are out-of-market efficiencies, and as economists, we can perfectly assess those. Environmental economics offers lots on that. So conceptually, empirically, we can deal with all of that, and we can take them into account. And those out-of-market efficiencies or reductions of externalities or benefits for non-consumers, it's all more or less the same thing. They're, of course, great. I mean, we welcome them. But the point is that the question on the table is whether we should take them into account by exempting agreements. And there my answer is strictly no again, because of the warnings that I made and that I gave for the risks involved in that. There's really no reason to think that the incentives are right if we are going to agree on cooperation. They are not going to bring about those positive effects more than in competition. Now, having said that, so coming from that perspective, let me point out 3 or 4 peculiar issues, very, very briefly, peculiar issues with this citizens welfare concept. What it introduces, first of all, it introduces a political dimension into competition law enforcement. Because now the competition authority is going to look at a very nitty-gritty, detailed level at what should consumers be allowed to pay more to the benefit of non-consumers, somebody else somewhere out in the economy. And I don't think that that is a role, and Vanessa was alluding to this also already in terms of political mandate, that's a role for competition authorities to do that. So that points to the government regulation instead. Competition authorities will, so this bringing in out-of-market efficiencies will introduce, second point, will introduce enormously large expansion of the required information for competition authorities to look at whether there's sufficient compensation for the now larger group of all the citizens. We need to know the preferences of consumers about these externality benefits and so on. That's going to be super difficult, and so increases the space for companies to do cartel greenwashing. So that aggravates the risk of cartel greenwashing. Also, by doing this, it will easily justify agreements, much more easily. And to just give you my last point, just give you the strange intuition that that brings. And so we already have this problem that in cooperation, companies are going to try to do the minimum amount of green for the maximum amount of price increase. So that's just how their incentives are if they can cooperate. There's nothing bad about that, but that's why we actually protect competition as a process. Now, if you're going to expand the set of people that can benefit, so if you're going to weaken the compensation requirement, what does that mean? That means actually that a cooperative agreement can get away with less green in compensation for the same price increase. So this goes entirely against the whole objective. We want to stimulate more green, but now we're going to allow them to get away with less green for the same price increase because we've been throwing in all these other people that are also accounting as beneficent. And so I think that is aggravating both of the risks that I pointed out before, and therefore, while we can absolutely do it, I think we shouldn't.
Okay, well, thank you very much. So at this stage, Margareta, do you want to say something, or do you prefer me to kind of intervene in the discussion? What would you prefer to do?
Pierre, I'm conscious of time, so I'll leave the floor to you.
Okay. So in terms of the discussion, let me try to summarize 3 of the questions that appeared on my board, and that, of course, have to do with long-term versus short-term. So one of the questions, for example, was that some of the environmental benefits are very long-term benefits. So even if it's within market, we might, by using our usual horizons, underestimate those benefits. What should we do about that? There was a corresponding question that say, well, but also that means that environmental benefits are also for future generation. So in terms of the requirement to pass through a significant part of the benefit to consumers, should we also kind of factor in this kind of future generation? And there was a somewhat related issue, which asked, look, you've said that the incentive for firms are not necessarily completely aligned with the incentive for society in terms of creating kind of green benefits. Is there a difference between this discrepancy in the short run and in the long run? Who would be willing to tackle some of this? Let's start with Doug, and then Martin is also a volunteer. Yes, Doug?
So I think there's certainly room for long-term benefits, and I believe they need to be considered. I mean, we have the Green Deal timelines that I think give us very good guidance in terms of which relevant time horizon should come into play to the extent that we want to consider benefits and out-of-market efficiencies. I think that's a useful guidance. I think more generally speaking, the competition law already today gives leeway for more than short-term benefits, as Vanessa said. The fair share criteria also allows for future consumers to be considered in the assessment. So I think the existing framework is fit for purpose, and if we apply, if you will, a Green Deal reading, long-term benefits can and should be taken into consideration in a very diligent and very clear fashion to avoid any risk of greenwashing and pre-tax and claims that are not being substantiated or not quantifiable with the appropriate methodology.
Before I turn to Martin's, Vanessa or Margareta, do you have something to say on this? Raise your hand if not. If yes, sorry. Okay, so Martin, the floor is yours.
Yes, thank you. So this is an excellent question. And of course, this is about long-run benefits very much for future generations also. It's possible for us economists again. So there's a great recent paper in Econometrica about this, for example, to take into account what's called intergenerational altruism or bequest motives. So the current population, current consumers, current citizens, but consumers also, they have an awareness and an appreciation for future generations, for bequesting a world that is green and beautiful for their children and their grandchildren. And so this very appreciation goes into the willingness to pay for greener products, and therefore automatically is taken into account in both the incentives on competition and any compensation. And so I think there's a lot of hope here because studies show that this kind of appreciation, this awareness, and the Green Deal and all the marketing around it is very helpful in this regards. That this appreciation is growing in current population. People have become more and more aware of this. And so automatically this being taken into account, consumers will shop and select the companies that offer a perspective also for the long run and saving the planet.
Thank you. Now, we've been doing good time, so let's maybe finish with a last question. This is a question from Maurice Dolmans. Where consumers are not willing to pay for green, market failures and regulatory failure occur. Why not allow proportional cooperation where there is no willingness to pay? And I would like to add kind of my own question to this, is that if there's no willingness to pay, to some extent, why should we care? So who would want to take on the double
Sorry, care about what do you mean, Pierre? Why should we care about what?
If consumers are not willing to pay, on what basis should necessarily government care? Yes, Dirk?
Yeah, I think I can build on what I said previously. There is this phenomenon which I think is called hyperbolic discounting, which means that consumers do not take into account the long-term consequences of their buying decisions, which again is a behavioral bias, I suppose, that we all have. And there is evidence that strongly suggests that consumers, when they're in front of the shelf, do not take a long-term impact of their decision into account. And that they also may feel that their individual decisions are not really making a difference, while it's, of course, then the entirety of consumers that contributes to change and more sustainable practices through their buying decisions. So what I'm trying to say here is if we rely too much on the individual decisions of consumers, we might be ending up with results that will not help us achieve the Green Deal objectives. I agree with Martin Peter that consumers more and more are indeed engaging in sustainable decisions. But I think it's a long-term process and it's not fast enough. I think we have to move much faster. When I look at the penetration of organic foods in German supermarkets, the first organic food supermarket was opened in 1987, and still only 6% of food in Germany is actually organic. I think we cannot afford to wait that long. And yes, we have to trust that consumers are ready to switch, and many of them are. And of course, information, as Vanessa said, is absolutely pivotal in that space. But I think there's certainly a case to be made that under certain circumstances and in a very careful manner, we shouldn't only rely on on consumer willingness to pay decisions.
Essentially, your point is that we often say that business is myopic, but consumers can be also either myopic or time inconsistent, the hyperbolic rate. So for the reason why we might want to intervene in things like payday loan, for example, because we know from behavioral studies that consumers do not really foresee all the future handicaps that's going to stem from those loans, we might want to incorporate this kind of behavioral bias in our approach, both regulation and competition policy. We're getting out of time there, so I know Martin is jumping in the bed, but he's going to have to live with this, especially because it's 58. And at 1 o'clock, this being the first Thursday of the month, we're going to have the fire alarm in the building. And no, we couldn't do anything about it, which puts, to the death, the myth that Executive Vice President Vestager is all-powerful, which is, a myth that gets credence every day, but here is being kind of proven wrong. So thank you very much for your participation. And here to kind of close the session.
Thank you, Pierre, and thanks to our panelists. Indeed, we don't want to meet the alarm, so we're going to close now. This morning we have received a lot of food for thought, so now let's actually go get some food. Bad joke, sorry. But this is to say that now we are going to have a lunch break, and we will be happy to welcome you again at 2 o'clock for our fourth panel on state aid. Have a nice lunch break. Bye.